Welcome to the Benefits Executive Roundtable, hosted by Dorothy Koshu, President of Advanced Benefit Consulting. Dorothy is a nationally recognized benefits and compliance consultant and group health broker. Here, you will watch and listen to industry experts who will break down the latest trends in employee benefits, healthcare reform, state and federal legislative and regulatory activities, all designed to empower executive decisions. We are proud to bring to you all new for Season 6 video podcasts. We hope that you enjoy your new video podcast format, and please forgive any audio or video imperfections. Thank you for viewing and listening.
Welcome to the Benefits Executive Roundtable. I'm your host, Dorothy Koshu, and I want to welcome you today. I hope that you all had a very nice, wonderful, and incredible holiday. And speaking of holidays, I'm sitting here in my Big Bear Lake, California home, mountain community in San Bernardino County, California. And I have with me today my special guest, Marilyn Monahan of Monahan Law Offices. Thank you, Marilyn, for being with me today.
It's a pleasure being here in Big Bear, and it's a pleasure being here to discuss this very important topic here today.
It really is, and it's nice because, you and I are usually doing this through Zoom. You're in your office, and I'm in my office, and we don't have a chance to be sitting together and actually having a conversation. So it's kind of nice that we can do that today and, share this information with people and have it, you can see both of us together, kind of having a real conversation for once.
We're going old school.
Going old school. Yeah, instead of having everything done, via computer. So it's nice being able to sit down at the table and have a conversation. So again, thank you for being here today.
Well, it is a pleasure being here in this very lovely community and having the opportunity to discuss this topic with you face to face. And I just hope that everyone had a wonderful holiday season, and I want to wish everyone all the best for the new year.
Well, thank you very much. And we're actually recording this, just so you know, on December 23rd, right before Christmas, and this is going to be airing after the holidays. So yes, not only we're saying have a happy holiday, but we're also saying Happy New Year. But the reality is for us, Christmas hasn't happened yet, but it will soon. So anyway, this is kind of an interesting way to do this. But again, we thought it was a nice festive way to record this podcast today. So thank you.
Well, and this is what happens when you have compliance deadlines that fall near the end of the year.
Yeah. Don't they do that to us all the time, though?
It does seem like, along with the other compliance items you have to add to your end of the year to-do list and your going into the new year to-do list, they've created some new obligations for us.
Yeah, I just love the effective date of today, December 23rd, 2024. Again, which is the reason why we're doing this today. We thought it'd be fun to do the recording actually on the day that it was effective. So anyway, it's just an interesting way we thought that we'd go about doing this today. I asked Marilyn to have this chat with me here today to discuss the new HIPAA privacy rule to support reproductive healthcare privacy, which, as we said, goes into effect today, December 23rd, 2024. Again, just in time for the holidays, right? Good timing, as usual, as we said.
As always.
Yeah, for sure.
To keep us all on our toes for the holiday season.
Absolutely. Well, let's talk about some of these new developments in reproductive health care. You and I recently recorded a detailed video for our clients at Advanced Benefit Consulting on this new rule and provided them with all kinds of tools and samples and so forth, everything basically that they needed in order to comply with this law. Thank you very much, by the way, for doing that with me.
I was pleased to do so.
And she did that for me, really stepped up, because I had laryngitis and I wasn't able to do a lot of the talking that I would have normally done. So I really had to rely on Marilyn to record a lot of that video. So thank you very much for doing that. My clients truly appreciate that as well as I do. So thank you.
I was glad to be able to be of assistance to you.
And I really, really did appreciate it, as I said, because it wouldn't have happened. I literally had no voice, no voice, what I do for a living. So anyway, thank you again for doing that. As I said, our clients really, truly appreciated that. And I know that there were regulations issued by HHS and OCR in April of 2024, which amended the HIPAA privacy rule to prohibit the use or disclosure in specified circumstances of protected health information relating to reproductive health care. We're going to come back to this in greater detail, I'm sure, in a bit, but in general, can you very simply tell us what is required by December 23rd, 2024, today, right, for plan sponsors and health issuers? What's required?
Well, as of December 23, 2024, the amendments to the privacy rule went into effect, and so covered entities and business associates have to comply with the rule or the amendments to the rule as of December 23. So they have to update their policy and procedure manuals, and they have to start implementing the new rules. And what that basically will mean is they cannot use or disclose PHI related to reproductive health care in ways that are prohibited by these new amendments to the HIPAA privacy rule.
Thank you very much. Well, there's a lot more to this. What's effective later and when?
So there is another effective date related to this amendment to the HIPAA privacy rule, and that is February 16th, 2026. And by that date, covered entities who are required to send out notices of privacy practices must send out amended notices of privacy practices to reflect the changes in the law brought about by these amendments.
Well, thank you for that. Please explain to our audience what exactly is prohibited related to uses and disclosures as far as the HIPAA reproductive rights are concerned.
Under these new rules, you cannot use or disclose protected health information related to reproductive health care if it's being requested to conduct a criminal, civil, or administrative investigation into or impose criminal, civil, or administrative liability on any person for the mere act of seeking, obtaining, providing, or facilitating reproductive health care, so long as such health care is lawful under the circumstances under which it is provided. In addition, it cannot be used for the identification of any purpose for the reasons I just described.
Thank you very much. I noticed you were looking down at your notes, and I don't blame you because that's a mouthful, all that stuff. So I'm actually relieved that she had the notes in front of her because I wouldn't have been able to do it if I were you. I wouldn't have been able to memorize that. So
I wanted to make sure I was properly quoting the mere act of seeking, obtaining, providing, or facilitating reproductive health care. I didn't want to leave one of the words out of that chain.
And you're an attorney, so you have to.
Right.
Me, I would have just, I could wing it. You can't wing it. You're an attorney, right?
I try to be specific when I can.
Right, exactly. Well, this all came about for the most part because of the Dobbs decision a couple of summers ago and the Biden-Harris administration's attempt to protect reproductive rights, correct?
That is correct. After the Dobbs decision came out, overruling years of jurisprudence on abortion coverage, which emanated from the Roe versus Wade decision, there was a concern about how protected health information, PHI, related to reproductive health care could be potentially accessed or disclosed. And so these rules address those concerns.
Right. So tell us about the application of the prohibition.
The prohibition applies where the relevant activity is in connection with any person seeking, obtaining, providing, or facilitating reproductive health care, and the regulated entity that receives the request for PHI, such as the covered entity or the business associate, has reasonably determined that one or more of the following conditions exist. That the reproductive health care, when it was provided, was legal under applicable state law, that it was legal under applicable federal law, or that they could apply a presumption that the reproductive health care was provided lawfully.
Okay, thank you. So please tell us a little bit about the scope and the definitions that are new, because there are some changes.
They have added some new defined terms, and they've altered some existing defined terms in the HIPAA privacy rule. For example, they made some changes to the definition of person that was already in the HIPAA privacy rule, and then they added a definition of reproductive health care. They explained in the preamble to the regulations that various phrases, such as the definition of reproductive health care, as well as that phrase I quoted earlier about seeking, obtaining, facilitating reproductive health care, should both be interpreted broadly for purposes of applying the prohibition.
Okay, thank you very much. And so tell us, what do they mean by the presumption of lawfulness?
So when reproductive health care is provided by a person other than the covered entity or business associate who's being asked to produce the PHI, the covered entity or the business associate can presume that the reproductive health care was provided lawfully unless that entity has actual knowledge that the reproductive health care was not lawful under the circumstances in which it was provided, or has factual information supplied by the person requesting the PHI that demonstrates to the covered entity or business associate a substantial factual basis that the reproductive health care was not lawful under the specific circumstances under which it was provided.
Okay, thank you very much. That was kind of a mouthful.
It is a bit of a mouthful, and I was, this is all very new, so we're going based on the text of the regulations themselves, which tend to be written in a certain amount of legalese.
Right.
I will say that HHS and OCR have issued some guidance to help us work our way through this process.
Yes, for sure. Thank you very much for that. There's also a very important attestation requirement. Can you tell us about that?
Yes, I can tell you about the attestation. It will not apply in all circumstances. So if you are a covered entity and a business associate and you receive a request for PHI that is for either health oversight activities, judicial and administrative proceedings, such as a subpoena, law enforcement purposes, or disclosures to coroners and medical examiners, and that the PHI you would be disclosing in response to one of those requests is potentially related to reproductive health care, then you must get an attestation from the person requesting the PHI, asking them to specify, among other details, that they're not asking for it for one of the prohibited purposes we talked about at the outset.
Right. Well, thank you. How do pre-existing provisions of the privacy rule continue to apply here?
Well, one of the things that they've stated in the guidance is they have emphasized that these new rules only apply to the specific circumstances that we have been discussing. Other provisions of the privacy rule remain in place. So if someone is seeking PHI for a purpose that was where use or disclosure was previously allowed under specified facts and circumstances, those continue to apply. They have not changed.
Okay, so basically HIPAA privacy pretty much stands. They've just added this new stuff to it. But everything that was in place prior stays in place. We're just adding all the reproductive stuff. I just want to make sure that people understand that.
That is correct. So if you do get a request for PHI that is potentially related to reproductive health care, there will be additional analysis you will have to do. There may be additional limitations or hoops that you have to jump through in order to use or disclose that information, or there might be circumstances in which you cannot use or disclose the information. But separate and apart from those circumstances, the rest of the HIPAA privacy rule remains intact, so that there will be many circumstances under which the processes and procedures you were following under the HIPAA privacy rule remain in place, and you will not have to alter the steps that you're taking in order to ensure that PHI is protected and is not disclosed to people who are not entitled to have access to it.
Thank you very much. So let me ask you this. In general, what do plan, and I know this is a big question, this is kind of loaded, but and I don't have time to get into all the details or anything, but in general, could you tell us what do plan issuers and health plan sponsors need to do, as action items? Because there are several steps that they have to take.
There are several steps that they have to take. And let me take this time to emphasize, it's not just health plan sponsors and issuers that have to comply. It's also business associates. Mm-hmm. So if you are a covered entity, and that could be an employer-sponsored health plan with a self-funded plan, that could be a health insurance issuer, such as an insurance company or an HMO, or that could be a healthcare provider, you have to comply. But also business associates of those covered entities also have to comply.
And I think that's something that most people are not thinking about. I think a lot of brokers and consultants, for example, are not realizing that this has anything to do with them.
That's very possible, but in fact it does. The rules specifically apply to both covered entities and business associates. What you have to do in order to comply will vary to some extent depending on how you have set up your HIPAA administrative processes. I would say for almost all entities that are obligated to comply with HIPAA, probably your policy and procedure manual is going to have to be updated to reflect these new changes. It is also possible that your plan document or your wrap plan document may have to be updated. It is possible that your business associate agreements may have to be updated, and you're going to need a valid attestation. So it's going to take someone sitting down, making an analysis of the existing materials that you have, and making a decision as to whether or not they have to be supplemented or updated in order to reflect these new rules.
And is it possible that even perhaps that someone's employee manual has to be updated if they do talk about HIPAA in detail in those manuals?
It's possible depending on what level of detail they go into in about HIPAA privacy. Right. what you would probably be looking for there, because the employee handbook probably doesn't go into extensive detail about HIPAA privacy, is whether or not there's any contradictory statements.
And let me ask you about this. What about training? Because training is such a big part of the HIPAA privacy rule.
That is another important provision. In addition to amending the policy and procedure manual, which probably almost all covered entities and business associates will find themselves having to do, although it all depends, but there's very good chance that that's the case. They at a minimum need to be reviewed, but they probably are going to have to be amended. But also HIPAA training materials. So you're going to want to update your HIPAA training materials as well as provide updated HIPAA training to those who need to know about this information.
And that's anything as of December 23rd, 2024 or after, correct?
Correct.
Okay. So that means a lot of you, right from the first of the year, right if you come back after your time off here from the holidays, you might want to jump on this if you haven't already, because it needs to be done now, because again, it's effective today, December 23rd, so keep that in mind. Well, tell us about potential penalties, since we're talking about all these things that you have to do as action items. What are some of the potential penalties in general for plan sponsors and issuers and business associates if they don't comply?
Well, the penalties under HIPAA are quite expensive, and they adjust every year. So you don't want to violate HIPAA, because it's a very expensive proposition if OCR comes in, audits you, and discovers that there has been a violation of HIPAA, which could come about because they could send you an audit letter, or an employee can complain to OCR that they believed that their PHI has been used or disclosed improperly. And you also have to keep in mind that although HIPAA does not provide a private right of action, if this disclosure also violated a parallel state privacy law, you could be looking at a lawsuit under state privacy laws.
Yeah, so it's important that you understand this, and that you understand that this is not something, you don't have 6 months or 2 years or 5 years to do this. You need to jump on it right away. The penalties for all of HIPAA are significant, and it's basically the same as the regular HIPAA penalties, correct?
They are the same.
Okay, so if you've had regular HIPAA training prior to the reproductive rights training, then you'll be familiar with that already. And this is just another thing that you have to add on to that, another thing you might be potentially liable for. So, Marilyn, thank you very much for all of this wonderful and valuable information. And thank you even more for agreeing to take some of your holiday time, when we're supposed to be somewhat relaxing over this holiday period, to sit here with me, like I said, in my home in Big Bear Lake, to do this on December 23rd. So thank you very much for doing that.
Well, I'm very happy to help try to explain these new rules, which take some work, take some analysis to understand and to grapple with, and to figure out what next steps need to be taken by employer-sponsored health plans as well as business associates. So these rules are not necessarily easy to understand, especially at first blush. So I'm very pleased to have this opportunity to chat with you about them and to provide some guidance to people as they try to work their way through their new compliance obligations.
Yes, absolutely. Well, if you need help with all of this, from a broker or consulting perspective, of course, you can contact me. I would love that at Advanced Benefit Consulting. We can certainly help you. But for legal assistance related to any of these issues, Marilyn can help you as well. This is what she does. She's very, very good at this stuff. I rely on her entirely for this sort of thing, and you can too if you need her. Marilyn, how would people reach out to you if they need assistance with this?
Probably an email, marilyn@monahanlawoffice.com.
Okay, and you are doing quite a bit of this to help people right now, correct?
Yes, I am. I've been quite busy amending plan documentation and contracts and so forth and so on.
And working with me to make sure my stuff is done, because that's what we spent the last couple of months doing, is working on all of that stuff for our clients and prospects and so forth. So I want to thank you again, because I really do appreciate that. And like I said, it's great that we could do this, here in a mountain community,
in a beautiful setting,
rather than doing this from our various offices and being isolated and not having this face-to-face time. So I do really appreciate you. Thanks again, everyone. Please stay safe, stay healthy, and stay tuned for the next episode of the Benefits Executive Roundtable. And by the way, Happy New Year to everyone.
Absolutely. Happy New Year and all the best for 2025.
Absolutely. Thanks, everyone.
Thanks for watching. Stay tuned for compliance tips, cost containment ideas, new trends, and decision-making tools. This podcast is produced by Advanced Benefit Consulting, Anaheim, California. All views expressed are those of the host or interviewees and not necessarily the views of Advanced Benefit Consulting. Information contained herein should not be construed as legal advice. We always recommend that you consult with your legal counsel as situations do vary. Ms. Koshu can be reached at 714-693-9754 extension 3 or toll free at 866-658-3835. By email at dmkoshu@advancedbenefitconsulting.com or visit our website at advancedbenefitconsulting.com.